So specifically on Sizzlers, in terms of criticism, really the only, I would call it criticism I've received is something that people say a lot about the cases that I cover. Why are you dragging up old stories? My usual answer to that is, for these victims and their families, it's not an old story. It's a story they live day to day. And just because to us it happened 20 odd years ago, to them it's their current reality.
Parole is a manner of placement whereby an offender, subject to completion of a minimum period of a sentence inside the correctional centre, and subject to certain criteria being met, may be allowed to serve a part of his or her sentence in the community. Singabako Ngumalo, spokesperson, Department of Corrections.
Hey folks, I'm NJ and welcome to Crime Most Queer. There has long been calls for serious parole reform in South Africa, especially considering that convicted killers Donovan Moodley and Adam Wust are already in the process of applying for parole. However, when news broke that former Cape Town policeman Marius van der Westhuizen had been granted parole just 13 years after he was sentenced to 24 years in prison for the 2006 fatal shooting of his 3 children, aged 16, 5 and 21 months, it sparked outrage across the country, and even inspired his ex-wife Charlotte to finally break her silence. Dr. Peter Groenewald, the newly appointed Minister of Correctional Services, ordered a review of the decision, and when the Correctional Supervision and Parole Review Board revoked van der Westhuizen's parole, it was seen by many as an encouraging step in the right direction. Today, we're deviating from our regular storytelling format, because I want to explore the South African parole system and address the failures and the shortcomings in its implementation. Specifically, I want to answer 4 main questions. 1. Is the South African parole system failing victims of violent crime and their family members? 2. Would implementing a whole life enhancement for those sentenced to life imprisonment, especially for heinous crimes, improve the South African parole system? 3. Would a sentence of life without the possibility of parole run afoul of the South African Constitution? And 4. Is there a way to ensure unrehabilitatable offenders are kept off the street without changing our laws to accommodate a sentence of life without parole?
Crime Most Queer is an LGBTQ true crime podcast intended for adult audiences and may contain graphic or disturbing content, including detailed descriptions of violence, physical or sexual assault, injuries to victims, and foul language. If you feel this may trigger you at all, please reconsider listening.
So, to help me answer those questions, I'm joined by Nicole Englebrecht, host of the award-winning podcast True Crime South Africa and the author of Samurai Sword Murder, The Morne Harmse Story, and Sizzlers, The Hate Crime That Tore Sea Point Apart, which I was honored enough to be asked to contribute to. Her latest book is Killer Stories, Conversations with South African Serial Murderers, which she co-wrote with Dr. Bryn Hodgkiss. So thank you so much for being here, Nicole. I'm so glad that we could finally get this to happen. And I just want to give another shout out to the team here at Dreamstream who have helped solve our technical difficulties.
Thank you so much. I really appreciate it. I'm glad to be here.
Okay, so let's dive straight in. How did you get into true crime?
So 5 years ago, I was working in corporate management. I'd worked in corporate management for 20 years and decided I wanted to start my own creative entrepreneurship, doing something a bit different. And the podcast was really going to be a small part of that. I was going to do some freelance writing, a couple of different, lots of different streams of income. And the reason I chose true crime as a genre for the podcast was because I was a true crime consumer. And I could not find a South African true crime podcast. So I decided to make one. And that's really where it started, and also just seeing like the UK and the US podcasts that were doing such good work in, real world change, bringing in leads on cold cases and things like that. And I think that's really one of the things that inspired me to get going with podcasting in specifically in true crime.
Well, you are the reason I started ACMQ. Yours was the first South African podcast that I found that I could actually relate to. And then, as you know, we chatted offline, and you said, well, why did you start your own? And that's how this came about. So True Crime South Africa isn't your only podcast. You also have another podcast called I Lived Through This. For those who don't know, tell us what that's about.
Sure. So I Lived Through This is really, I think it stemmed off True Crime South Africa because, once I got about probably 50 episodes deep into True Crime South Africa, I started realizing that people were contacting me with these stories that didn't fit true crime, but were incredible survival stories. So I started I Lived Through This as a place to platform those voices. And really also, True Crime South Africa, often those episodes don't have happy endings. And I thought that at the time, it was around 2020 when I came up with the idea, and I really thought my listeners needed something with a bit of a happy story, survival and a inspirational sort of twist to it. And it was very helpful to me too, because it gave me a bit of a palate cleanser, if you will, from the true crime stuff. So I unfortunately had to put that podcast on pause when I got my first book contract, and we'll be restarting it again. But that is out there in the world.
Now, I must say, I thoroughly enjoy, as you say, it's a palate cleanser. It gives us a chance to step away from everything. For your books and podcasts, you speak to people about truly terrible times in their life. How do you get them to speak to you? Because in my experience, trying to get people to talk to me is a challenge.
So I guess this had two different phases for me. In the beginning, I struggled to get people to speak to me. Understandably, no one knew who I was or what I was doing and didn't quite understand the concept, and there was no trust developed or reputation developed yet. So in the beginning, it was quite rough. And I think really what helped me to get through to people was focusing on the victim-focused elements of the podcast. And once I think family members and friends of victims of violent crime came to understand that I was not coming at them from a mainstream media focus. I wasn't there for a salacious take on what had happened to them. I really wanted to introduce listeners to who their loved ones were as human beings. That really helped. Yeah. And then, the second phase happened where True Crime South Africa has seen some success and, the word has spread. A lot of victims give each other support and meet each other and talk to each other. So I've now started to have people contacting me, families contacting me, asking me to tell the stories of their loved ones. So it's become a lot easier. But of course, there are always those family members who do not want to engage in anything like that, and that's also completely understandable.
Yeah, I found my very first case was one I had a direct connection to. The killer was living in my best friend's house. And so the first case was really easy. I managed to get hold of the prosecutor and she sent me pretty much everything. Yeah. It was the first time I'd seen uncensored crime scene photos, which shocked the shit out of me. And then I thought, okay, well, there's a story I really want to tell, and that's Sizzlers. Nobody wanted to speak to me.
Yeah.
I tried to get hold of I got hold of one of the reporters that covered the case back in 2003, and she went, "Who are you?" And I went, "Sorry, I don't know you. Sorry." So it was very difficult. But now, we've both covered Sizzlers. Like I said, for me, it was, I went into it as a really green podcaster. You went into it as a hardened podcaster, but a new author. How did you find working on Sizzlers, on your book on Sizzlers, different from how you covered crime in your podcast?
So I think that, Sizzlers as a case is very different in terms of the number of victims, firstly. So, it was one of my podcasts multiplied by 10, pretty much, in terms of work, in terms of trying to track people down. So from that perspective, it was quite different. I think that, and sometimes it sounds a bit woo-woo when I say this, but what I found with my first book, Samurai Sword, and many of the podcasts that I've done really is I almost feel like when a story is ready to be told, the people come to me.
Okay.
Because what I saw happening in the lead up to, in the years before I wrote Sizzlers was individuals who were related to the case finding me. And not necessarily because they ever thought I would write a book about it. It was just a case that had weighed so heavily on so many people's minds, and they wanted more answers. So I was having the paramedics, one of the paramedics that was there that night contact me, Lee Visser, one of the victim sisters. So that was similar in a way, but also quite different because that was already, all that research was already almost built up by the time I first put pen to paper.
Okay. Have you received any criticism for writing Sizzlers? Did you get anybody? I know when I covered Sizzlers, the first time I actually got a response from a member of the audience was Marlene Visser, Lee's mom. And she went, "You got stuff wrong."
Yeah.
And I went, "Oh, okay.
Yeah.
Please help me, correct me." And when I interviewed Lee 5 months later, I tried to correct the issues I had, but I felt so bad because I got stuff wrong. So has anybody come to you and go, "Nicole, you f***ed up"?
So specifically on Sizzlers, in terms of criticism, really the only I would call a criticism I've received is something that people say a lot about the cases that I cover. Why are you dragging up old stories? My usual answer to that is, for these victims and their families, it's not an old story. It's a story they live day to day. And just because to us it happened 20 odd years ago, to them it's their current reality. I know in terms of getting things wrong, I'm sure there's one or two things wrong. I know that there was something that you mentioned to me that I got wrong in your chapter. Yes. So I don't know if you want to elaborate on that.
No, basically, I just wanted to say that we never sat naked. Being a gay brothel, we were a target for undercover cops.
That makes sense.
And a woman could walk around in pretty much nothing and no worries.
Yeah.
A man does something with another man. Oh no! That's not going to fly.
Yeah.
And so we had to always be presentable. We need to look like we could walk into a nightclub. And the other thing we used to do is we had to make sure that the client undressed first. Right. What we were told is that if we were naked before, we could get done up for solicitation. If the client was naked before, then it would be entrapment. I have no idea if that's true or if it's just a line they fed us. But yes, that's something that we did do. We did have underage kids working in our agencies, and we did tend to take them under our wing. But it was either they work there, get money, be able to eat, have a roof over their head, or they're living on the street at the age of 15, 14.
Yeah,
it's shocking how evil some parents can be to their own kin, and it's not ideal, but it offers them money in their pocket and a roof over their head.
Sure.
So we just learn to protect them. I want to move on to today's topic, the South African parole system. Now, correct me if I'm wrong. You've done 167 167
Yeah.
episodes of True Crime South Africa, and they're out there roaming wild. You've touched on a few other cases, or many other cases, where the parole system has been a factor. Could you walk us through some of those cases?
So I think in terms of the podcast, very many of the child cases where there have been child rape and murder, there we often see offenders having been previously convicted of child crimes. We know that pedophilia is one of the most difficult crimes or disorders to rehabilitate, and the criminality around that is very difficult. So those are often parole issues where we see parole boards not understanding that these child offenders, or offenders against children rather, are not rehabilitated and releasing them, and then the cases I've covered on my podcast end up being murders, unfortunately. And very many of the serial killer cases, in fact, especially where there's a sexual fantasy element against female victims, almost always starts off with a serial offender having committed rape, gone to prison for the rape, and pretty much when they're in prison, almost saying to themselves, when I get out, I won't be coming back in because the victim won't be allowed to tell the tale. And that is when they start raping and murdering their victims. And so those are really some of the ones that stand out for me in terms of seeing how important it is for the parole system to work the way it should to protect society.
Okay, and before we get to the professional opinion on the parole system, I want to find out, what's your personal opinion of how parole is handled in South Africa?
So I think that's changed for me over the years. When I came into this as someone who didn't have very much knowledge, I would have said to you, why do people who've committed such horrible crimes even have to see the outside of a prison cell? I think that would have had one of the similar opinions to many members of the public. Now I understand the value of rehabilitation. I understand why the process exists, but I do have very strong views from having seen the pain that it has caused people that I've dealt with on the podcast and in the books. Very strong views about things that need to change and where it's falling down.
Well, let's take a quick break, and when we come back, I'll speak to two lawyers who have dealt with the parole system from opposing sides. Don't go away. First of all, the parole board. How qualified are these people to sit on this board?
So in my experience, not nearly as qualified as they need to be. What I've come across has been individuals who do work for the Department of Correctional Services, but not necessarily in a role where they would have criminological experience. Then, unfortunately, we also have heads of churches, pastors, individuals that, as far as I'm concerned, do not have a place in the criminal or the legal system.
I'm so glad you said that, because I was going, why? Why?
Yeah, let's face it, religion is important for many individuals in this country, and it's an important part of their life. But constitutionally and legally, it's not a part of our justice system.
DreamStream, a place to create yourself. Record video, music, and podcasts in our full-service studio. Record video, music, and podcasts in our full-service studio. DreamStream, a place to create yourself.
And welcome back. So Nicole, one thing that bugs me when researching my cases is that the victim becomes a footnote in their own stories. And this seems to carry forward into the parole system. Less importance is placed on the psychological impact of on the victims, or in the case of murder, the families. Now, in your book, Sizzlers, it's an exceptional read, and I urge anybody who hasn't already read it, hunt it down and find it. But anyway, you discuss the UK's whole life order. I've long been a strong proponent of this. But the UK isn't the only country that basically says you're going to jail and you're never going to see the outside of a prison cell. In Australia, a judge can decline to set a non-parole period, and an open-ended parole period handed down from the bench is a factor in many other countries.
In some countries, like the US and Turkey, there may be no possibility of release under any circumstance. In some, such as Vietnam, amnesties are usually granted after a prisoner has served 20 to 30 years. And in others, for example Bulgaria and Sweden, people can petition the government for a pardon. While life without parole has been abolished in most European countries, others, such as India and China, have adopted it as a formal statutory sanction in recent years.
In your book, you mention 2 lawyers who worked on either side of the parole system. And I had questions, so I decided to reach out. Julian Knight has represented several high-profile offenders in their parole applications, including Janusz, who was convicted of the 1993 assassination of Chris Hani, and Oscar Pistorius. He also appeared before the Constitutional Court many times on the topic of parole.
My name is Julian Knight. I am an attorney in private practice. What one has to understand is, firstly, South Africa is one of the few countries in the world that recognizes the principle of parole in respect of offenders. The idea in general terms is that an offender's behavior will be corrected, they will be rehabilitated and then reincorporated back into society. Now, you have to distinguish also then between various categories of offenders. You have offenders that are serving years imprisonment, that would be a determinate sentence, and then you have prisoners that are serving life. Added to that, we have a change in the law which occurred on the 1st of October 2004, which basically means that, in effect, if you were serving years, before 1 October 2004, you had to do a third of your sentence before being eligible for placement on parole. Now, anyone who committed an offence after 1 October, they will have to do half of their sentence before being placed on parole. In respect of people that are serving life, if you were sentenced to life imprisonment for an offence committed before 1 October 2004, your eligibility for consideration for placement on parole is at about 12 years and 3 months, and that is calculated on the basis of the credit system that used to apply before 1 October. If you are sentenced to life imprisonment for a crime that is committed after 1 October 2004, you have to do 25 years before you are placed on parole.
Okay.
So that is in general terms the legalese behind it. But with regard to any parole process, the most important part when a person gets to the position where they are eligible for placement on parole is the risk of recidivism, in that, are they going to pose a danger to society when released? In more serious offences, where you've and murder and stuff like that, you will have a situation where the people need to be psychologically assessed. Those assessments need to be processed, and sometimes the government asks for risk assessments by an independent criminologist, and they have to assess whether the person is not a danger to society by being released. And so those are the factors that the parole boards in general terms look at.
Okay, so that psychological assessment he mentioned, it caught my attention. And so I asked him if this was for all prisoners or just a certain category of incarcerated persons.
Look, in any person who is sentenced to imprisonment for any offence over 5 years is expected to, well, in terms of the B orders, that's the regulations applicable to prisoners, is that they must be assessed by a psychologist within 6 months of their incarceration, and then presented with a sentence plan. Unfortunately, it very rarely happens because we have very, very few psychologists in the prison system. So you will find in practice that a person will probably sit for 15 years, and just before he's eligible for placement on parole, he gets called to the psychologist for the very first time, who then says, "Oh, so let's have a look at your crime." There have been matters where there have been interventions earlier, but in my experience over the last couple of years, with the freezing of posts in the Department of Correctional Services, there's a huge lack of qualified psychologists in the employ of the department. You just got to think, we've got 160,000 prisoners in South Africa, which in itself should ring alarm bells, because if you think that we have a murder rate over the last 20 years almost equal to 500,000 South African citizens that have been murdered.
Wow.
We should actually have close to 500,000 offenders in prison if we had a functioning prosecution system and functioning police where crimes would be detected.
So yeah, that figure blew my mind.
Absolutely.
The fact that we have had so many murders, and then there are a lot of people in prison, but clearly not as many as there should be.
Yeah.
Also, the parole system seems to not only be failing victims, but also failing offenders.
You know, I've been really lucky in that I've been able to connect and network with people who work within DCS and become quite friendly with a few people within DCS. And I think I now see it from their perspective where, they are, of course, trying as hard as they can to see as many offenders as they can. But Julian is absolutely correct. They're under-resourced in terms of psychologists per capita for offenders. And it takes an awfully long time to hire new psychologists when, psychologists leave. And
why is that?
It's the cogs of the system.
Okay.
It's a governmental thing.
Okay.
The cogs of the system turning extremely slowly.
Okay.
So it might take up to 9 months in some instances for a post to be even re-advertised, not even refilled. So it certainly is a huge issue. The other side of this is that, yes, there are offenders that may take use of the psychological services available to them. But also it has to be a two-way thing. It's not something that can be forced upon offenders. So, I don't know which offenders Mr. Knight is referring to specifically where, 15 years down the line, they're then being given services. Did they actually want to avail themselves of those services earlier on? That's another question we have to ask ourselves.
Yeah. I wanted to find out about the victim side of the parole process. And so I spoke to Tania Koen. Now, Tania represented Reeva's parents, Barry and June Steenkamp. Oscar claimed that he thought Reeva was a burglar, and the courts disagreed. And eventually, after a bit of a up, he got 13 years and 6 months in prison. 9 years into his sentence, he applied for parole, and that's where Tania stepped in.
I'm an attorney by profession, and I am actually, my specialty is conveyancing, but I'm also the CEO of Reeva Rebecca Steenkamp Foundation. And because of that, I am involved in, supporting victims and assisting them with obtaining maybe a protection order or helping them to get to a safe place and so forth. So it was, and of course, you know that I've acted for June and Barry Steenkamp, who lost their daughter Reeva when she was killed by Oscar Pistorius. And then at one of my breakfasts, as a CEO, we also do fundraising events. And at one of those fundraising events, I invited Olivia Yasriel, who was Bob Hewitt's rape victim, to be our guest speaker. And after that, after being our guest speaker, she asked me to represent her. And that's where my journey with parole started.
So you've dealt with the parole system many times. Do you feel that in its current form, it is fit for purpose?
There are many aspects of it, most certainly, which are fit for purpose. The problem is it must be properly implemented.
Okay.
You know, if before you appear at the parole board hearing, when the case management committee, when they get their report together, there's a duty on them, and they must exercise that duty properly. What do I mean by that? They must make sure that they've got the case, that, you know, the perpetrator, they must have the relevant court documents in their file. They must read through that. They must read what the judge said, because without having that background, I don't believe that a proper decision or an informed decision can be made. And then there are other issues that I have a huge problem with. For instance, the psychologist's report. That is, for me, a big issue, because the psychologists have a meeting with the offender, and they then make a report. But that report is not shared with the victims.
Okay.
So we were in the position where I'm involved in another matter, and we applied to the parole board or to the department to have access to the psychologist's report. We only have access to that psychologist's report if the offender agrees thereto. If they don't agree, we don't see it. So it means that effectively we arrive at a parole board hearing, and the chairperson reads extracts from that report which he or she deems relevant. But it doesn't give us the opportunity as the victims to make an informed decision as to whether we think or whether we are persuaded that the offender has been properly rehabilitated.
Okay.
So only because the offender wasn't happy with the parole board's decision and actually made an application to court to have the parole board's decision reviewed, and as part of that application to court, the psychologist's report was included. Only then, because it becomes a public record, and of course we are party to it, then we could see what the psychologist's report said. And based on that report, we could see how much the psychologist did not take into account.
Okay.
How much information the psychologist was not aware of. So that is a big problem, in my view, in the process.
A lot to unpack there.
Yeah.
First of all, the parole board. How qualified are these people to sit on this board?
So in my experience, not nearly as qualified as they need to be. What I've come across has been individuals who do work for the Department of Correctional Services, but not necessarily in a role where they would have criminological experience. Then, unfortunately, we also have heads of churches, pastors, individuals that, as far as I'm concerned, do not have a place in the criminal or the legal system.
I'm so glad you said that, because I was going, why? Why?
Yeah, I mean, let's face it, religion is important for many individuals in this country, and it's an important part of their life. But constitutionally and legally, it's not a part of our justice system.
That's my feeling too.
And yeah, so to answer your question, unfortunately, I hope that it is getting better. But the boards that I have seen assembled, in my experience, are wholly unqualified to understand the criminal mind and the risk of recidivism.
On the topic of the psychologist report, what the the fact that the report is cherry-picked, for one, and that it's not given to the victims. I understand maybe it's a privacy issue, but my thing is, you killed someone, or you raped someone, or any number of crimes, serious crimes. You don't have a right to privacy in that regard. It's not like it's going to be splashed all over the papers, but it should at least go to the victims and the victims' counsel.
Yeah, it's a really difficult one. I absolutely understand from the victim side. I've seen it firsthand how frustrating it is. Considering the psychologist side of it, day-to-day psychologists outside of the correctional system do have a duty to their patients or clients to, keep what goes on in their sessions to themselves. And I would assume that would extend to the therapist-client relationship within the prison system. So that may be, it may be that element of privacy that's causing the report not to be shared. I don't know where we draw the line between the human rights of the offender and their rights to privacy, because not everything that is in that psychologist report might be relevant to their crime and them being released.
Okay. That actually does make sense. That didn't occur to me.
It's possible.
Yeah, I understand, because one thing I have found, and maybe you found it too, is, like I said earlier, the victim becomes a footnote in their own murder.
Yeah.
The life and history and what color underpants he wears is in the court documents. His entire life is put on full display, and I can write hours worth of profile on the offender, and I can get a paragraph if I'm lucky on the victim, which annoys the shit out of me.
Absolutely.
And it's one of the reasons why I do what I do. One thing I was unclear about was whether parole was a privilege or a right. So I contacted Julian. Am I correct in that parole is a right, not a privilege?
Parole, the consideration, the process to be considered for parole is a right.
Ah, okay.
But the placement on parole is a privilege, but it's a privilege in the sense that if you qualify and you meet the requirements, then you must be placed on parole. It's not you can't have an arbitrary system where, you'd have something, I just don't like who you are, and I'm not placing you on parole because it's a privilege, not a right.
Okay.
I think one has to sort of look. There are a range of factors that one has to take into account, and what one essentially has to do is to strike a balance between the offender, the crime, and society. And the unfortunate situation is that tough cases make bad law. If you have a look at the recent case of Janusz Waluś and all that the outcry from certain quarters with regard to his placement on parole, you had a situation where you had judges in 4 or 3 review applications who would remit the matter back to the minister, saying that the reasons he had given for the refusal were wrong, but that the minister must make a new decision. Then the minister makes another decision based on different reasons.
Yes.
And eventually it came to a situation where the minister then finally relied upon the seriousness of the offence and the sentence remarks that were made when the person was convicted. Now, those sentence remarks can never change.
Okay.
The only thing, so you have a situation that when a person goes into prison, the seriousness of the crime and the sentence remarks are sort of on the forefront. But as the person has served, 20 to 30 years of their sentence, then rehabilitation has to actually start being the balance on the other side.
Yeah. Okay.
But there's a range of factors. And the other thing is that the granting of parole is not dependent upon the consent of the surviving victims or the victim of the crime. Because if that were the case, we would never have anybody placed on parole.
Yeah. Okay.
So parole boards have to make a measured decision, take everything into account, and then make a rational decision.
As Julian mentioned there, parole is not granted on with consent of the victims. Do you feel that victims, there should be more weight placed on what the victim says, or do you think that emotions would totally screw with the parole system?
I don't know that we can ever determine how much weight is placed upon what the victim's opinion is, because it comes down to the votes of several different parole board members, and they make their own decisions based on what personally is weighted for them. For me, I think that where we would really benefit from starting is actually doing what we're supposed to be doing with the victims. So at the moment, rather than increasing the weight that their opinion has, which can be emotional in some instances, it really depends on the victims. I've seen some come across quite in a more level-headed manner. If they're not being involved as they're supposed to, then it's already not weighted to where it should be.
Okay, so I mentioned earlier that I've been a proponent of the UK's whole life order, and you mentioned it in your book as well. And I asked Tania if introducing this kind of sentence would improve our current justice system.
Again, eventually only the figures will be able to tell whether it was successful or not. But speaking from a victim's perspective, I have no doubt that there must be situations, and there indeed are. I mean, if you look at the judge's comments, there are a certain category, which there's a psychologist that says this person is a psychopath, or a psychologist's report to say that this person is unrehabilitatable. So I do think that there would be a certain category. And this is where one will have to be very careful. How do you define that category that one would think should not ever be able to qualify to be considered for placement on parole? Because not only the recidivism will be an issue, but also they will still pose a danger to society.
Okay, so do you feel that this would be something worth considering?
I think if we look at countries where it is used, so specifically the UK and England, they use it for about 2%, I think, of their cases. That's about 2% of their offenders. I think it's around there.
I think I saw it was something like 79
individuals,
people who've ever gotten a whole life order, and that includes those who've died off. I think it's very low.
And it's certainly. There's no doubt that it would add some value to our system, because at this point, I do tend to feel that even with our dangerous offender determination, we have sentences that do tend to lean too far onto the offender side of you always need to have that light at the end of the tunnel.
So for viewers and listeners who aren't aware, South Africa doesn't have a jury system. We used to. We definitely used to. It was introduced in the over a period of time in the 1800s, but by the early 1900s, they started to phase it out. In 1917, an act was passed that allowed offenders to choose to be tried without a jury. In 1935, an amendment was passed which authorized the minister to order a trial without a jury. In 1954, the Act was amended to establish that all trials would take place without a jury unless the accused specifically requested a jury. Eventually, juries were completely done away with by the passing of the Abolishment of Juries Act 34 of 1969, although there hadn't been a jury trial in something like 2 years before the Act was passed. The official reason given was that it was only because only white men could serve on the jury. The state didn't wanted to protect non-white defendants from the possibility of lynch mob type rulings. So I guess even the apartheid government can fall backwards into a ruling that served non-whites. So I asked Tania if our lack of a jury system would possibly open life without parole sentences to unchecked abuse.
I don't think so. And the reason why I say that is because the offender still has the right to approach a court, to have the decision reviewed or appealed. So there is something that they can do if they should feel they've been unjustifiably denied or whatever. So no, I don't think a jury system will make that much of a decision. On the contrary, I think that judges are not laypersons like a jury is. They would perhaps be more competent to make such a decision. That's why the National Council, it's a judge that heads up that committee.
Okay.
The National Council for Correctional Services is chaired by a judge of the High Court, and part of that is other professionals.
Okay.
So they are the ones that make the recommendation to the minister.
Do you think South Africa is stronger or weaker without the jury system?
I'm not a huge proponent of the jury system, specifically for South Africa. I have also seen examples of cases in the US where they do have a jury system, where the jury system has worked against people standing in the dock for certain crimes. In my opinion, if we look at a jury system as being representative of our peers, South Africa has a far too many sort of disparate socioeconomic levels for us to be able to say to a young man who has hijacked a vehicle and accidentally shot someone because he grew up without parents in a township, that these 12 white and perhaps coloured people from very different socioeconomic circumstances are now a jury of your peers. I think that difference is less so in the US and far too much so in South Africa for that to be useful for us.
Okay. I feel that a jury system has its place, but I agree with you that maybe we are just too diverse for a fair jury system. I want to turn our attention to Parole Reform International. Now, that's a Dutch-based NGO that promotes criminal justice, but with a focus on human rights. And they are staunchly against life without parole. On their website, they list a number of key facts. And I want us to go through a few of them and get your thoughts.
The number of life-sentenced people is increasing. In 2014, there were roughly 479,000 persons serving formal life sentences around the world, compared to 261,000 in the year 2000. Since the turn of the millennium in South Africa, there has been an 818% increase in the number of prisoners serving life, which stood at 13,190 in 2014. Between 2014 and 2020, the number of people serving life sentences increased in South Africa by 28%.
Currently, life imprisonment is a mandatory sentence for murder, where premeditation was a factor, for gang rape, serial rape, including where the offender knew they were positive, or if the victim is under the age of 16 or mentally disabled. For other types of murder, the minimum sentence is 25 years, 15 years for rape, and 10 years for robbery. However, in certain cases, people can be sentenced to life for cases, I think it's certain hijacking, certain robberies, and definitely aircraft hijacking. So let's not do that. Do you think life sentences maybe are used in excess in South Africa? Should we maybe not look at not sentencing to life?
No. So in my opinion, I think they're being used as much as they should be, especially if I look back at cases that were being sentenced even just 20 years ago. Cases where, if we look, for instance, at the Van der Westhuizen case we mentioned earlier, with that individual getting a determinate sentence rather than a life sentence. There are many, many cases like that where our understanding of the criminal mind and of elements like coercive control, stalking, etc., have improved to such an extent that we now understand that these are things that these individuals will continue doing. And if we don't give them a sentence such as life, they will get out and they'll do it again, because that's what they've done in the past when we've given them determinate sentences. So I really think the life sentence is now being used. I'm very happy it's being used as much as it is, and long may it continue.
Okay, great.
The length of time served under a life sentence also appears to be rising. For example, in England and Wales, the average time spent in prison has more than doubled for life sentence prisoners since 1979. From 9 years in 1979 to 18 years and 4 months in 2013.
Despite the length of time that a lifer now has to stay behind bars since the change of the, what was it, Van Wyk?
Van Wyk.
Since then, should parole not be completely off the table whatsoever until they've served the full 25 years? Because I'm noticing a lot of, like, for example, Adam Wurst, should the parole process not only start once they've served that full sentence?
So by law, everyone sentenced to life post-2004, so post-Van Wyk determination/judgment, should only be considered, essentially it's 24 years and 6 months. Because 6 months before their 25-year date, they will start, they being the Departments of Correctional Services, will start the process of inviting victims for victim offender dialogues and doing those sorts of preparation activities toward the parole hearing. There are, however, we still currently have 3 categories of lifers in our system. And this is where these differences come in, where it seems like life sentences are, these offenders coming up for parole far too soon. And it's because of the Van Wyk judgment, rather, where many of these offenders were sentenced around that time. So either just before, just after 2004. And as a result, they essentially got lucky, and they had their sentences judged under the previous sets of legislation, which allowed them to work on essentially a lesser period, 2/3 and the credit system. So that's where these are falling. And luckily, we are now moving into a time where those other classifications of lifers are now moving either through the system, or they've been released on parole, or they've been released and they've committed other crimes and they've come back in under the new life system. So it's starting to weed itself out.
Yeah. We actually spoke about the Marius van der Westhuizen case off camera. And I just want you to, I want to go through that again. You said that he wasn't given a life sentence. He was given a determinate sentence.
That's correct.
And which is why he was able to apply for parole once he'd served half that sentence. Is that correct?
That's correct.
He got preferential treatment, you mentioned, or in a way, because of who he was. Could you talk us through that?
Sure. So essentially what happened was when the sentencing process in the trial happens, the prosecution offers aggravating circumstances, which they think make the crime worse and therefore the sentence should be worse. And the defense offers mitigating circumstances for a lesser sentence. And one of the mitigating circumstances in the Van der Westhuizen case was that he was a police officer who had allegedly suffered PTSD. There was also some victim blaming, as far as I'm concerned, in terms of the defense, which is not uncommon, essentially saying that he had discovered his wife was having an affair, he lost his mind, and that's why he shot his children. And, you mentioned the different classifications of sentences for premeditated and non-premeditated. And the judge accepted that this was not a premeditated murder, although Charlotte van der Westhuizen completely disagrees with that. And that is why he got a determinate sentence rather than a life sentence.
I must say, I was speaking to a candidate lawyer a few years ago, and he said, we don't have premeditated murder in South Africa. I went, wait, what? He goes, there is no charge for premeditated murder. There is a charge for murder, and then they will take premeditation into account in sentencing. And I went, okay.
That's correct, yeah. And I think in a way, perhaps that is a good thing, because premeditation often only comes up through an investigation. And something may look not premeditated, but once, an offender being charged is not the end of an investigation. It's the beginning of an investigation. So, if you charge someone with, if we had premeditated and not premeditated, that may make it difficult when it comes to trial if you want to change from one to the other, or from not premeditated to premeditated. Yeah. So I kind of prefer South Africa's system in that regard.
Yes. Now, when you put it like that, it does make far more sense. Donovan Moodley, you've covered that case before.
Correct.
He's also started his parole process. Lee Matthews' father has been quite vocal on this. Is he making any headway?
So with the Matthews case, it's been quite, her dad, Rob, has worked very hard to try and keep Donovan Moodley behind bars. His take on it is that the remorse that the parole board claims Donovan Moodley is showing is not real, because he has not admitted the true circumstances of the crime. And that's part of when an offender comes before a parole board, if you're still not willing to, and especially in a victim-offender dialogue, if you're still not willing to tell the whole truth, then you cannot possibly fit that, elusive remorse requirement, because you're not remorseful if you're not telling the truth. And that is what Rob has been saying, essentially, is that because there's so many things that are still unexplained in Lee's death, and other individuals he believes were involved in her murder who were never tried and convicted, Rob is one of the reasons he's pushing so hard to keep Donovan behind bars, because he does not believe he has fulfilled the requirements. there have been many ups and downs and legal backs and forths. I know Tania Koen was also involved in that case. And sadly, I do think that we are, within the next couple of years, probably going to see Moodley released.
What you say is my issue with Adam Wust, is there are way too many unanswered questions still. I made it quite clear when I covered the case that I have my own, I believe one of the conspiracy theories. With every fiber of my being. And I just want to shake him and go, just tell the truth. But it just annoys me that we'll never get that.
Yeah.
The very first case that I covered, Gordon van Niekerk, I also believe that there is a far greater conspiracy in that one. And I'm actually going to be redoing that case as a video coming up because I want to explore the conspiracy theory more. The murder that happened before, where the eyewitness to that murder was killed by Gordon van Niekerk, the only eyewitness. He's going to be coming out in 2033. Surely, after all that time, you say something. Why not?
Yeah. I think also perhaps, if I may say, something to recognize about these individuals is that many of these crimes do involve an element of control and power. And many of these individuals, this is the little bit of power they have left. They've been powerless for the 25 years or whatever it is they've been in behind bars. And in a sick way, this is their only little piece of control and power they still have left, is the truth.
An excellent point. Hadn't thought about that.
Countries that abolish the death penalty tend to not only replace capital punishment with life imprisonment without parole, but at the same time widen the array of offences which carry this maximum sentence.
On this point, South Africa bucked the trend. And I discussed this with Julian.
One thing that I have noticed is a lot of countries that had the death penalty.
Yes.
When they took away the death penalty, they replaced it with life without parole. Now, South Africa didn't do that. Am I correct?
You are correct. We do not have a principle of life without parole. And I think if you have a look at our case law, my feeling is that even if the legislature were to embark upon changing the law to have a situation where a judge could declare a sentence and a whole life sentence, I believe that would constitute cruel and inhumane punishment, because there are cases which say that a sentence to life without the flicker of any hope of release at some stage constitutes cruel and inhumane punishment.
Okay.
And I think from that point of view, I don't think even if the legislature were to embark upon that and legislate a whole life sentence, I don't believe that it would pass constitutional muster.
That was actually going to be my next question, is would something like that not survive the Constitutional Court?
You see, there are other ways. There are other ways a judge can get around it. I mean, I've got matters where I've acted for people that have been sentenced to 100 years.
Okay.
Now, you being sentenced to 100 years imprisonment, the chances of you getting out at a half of your sentence or a third of your sentence, it's like 33 years or 50 years that you have to sit. So judges, if they wanted to get around, instead of sentencing a person to life imprisonment, they could actually give them years.
Okay. Ah, okay.
And get around it on that basis.
And do you think that would survive the appeal process?
Well, possibly not, because your first argument would be, well, if the person had been given life, they would have served less time than what they that they would have served under these circumstances.
Yeah.
But having said that, I've got many matters that I've had with, they've been thieves that have been, people that have done, house breakings and stuff like that, where they've kept on doing it, and the magistrates have then given them a cumulative sentence, which if you add it up and they say, well, it's going to run, it's not running concurrently, it's running consecutively, and you add it all up, and the person's serving close to 90 or 100 years.
Okay.
And those are for crimes, basically crimes of dishonesty, not crimes of violence.
So do you think that South Africa dropped the ball by, when we abolished the death penalty, not bringing in life without parole?
I think if I look back at South Africa's judicial history, and that relates to sentencing, death penalty, etc., it very much reflects the process that we needed to go through in this country in learning to trust a government again. Because, the death penalty was in the hands of probably the worst, which is the governments in our history which had the least regard for human rights. And when that was abolished and apartheid was abolished and the apartheid government was no longer, South Africans had to learn to have trust in the judicial system and in their government again. All South Africans, not just the 2% of South Africans that trusted it before. And I think that had we at that time introduced a life with no parole, that may have made it difficult. I think that is why we had to implement the constitution we had to implement, was to safeguard that process of developing trust. Okay. Looking back, we can clearly see that the non-parole period for life sentences has increased. So we've come to realize that, okay, this wasn't enough in 1994. We've added on, and now we're at 25 years, which is one of the highest non-parole periods for a life sentence in the world. So clearly we're doing okay there. But I think that those two processes had to happen parallel for the South African public to have any elements of trust in the judicial system and the government that runs it, essentially.
Yeah. Okay.
Despite increased recognition of human rights concerns around the use of life imprisonment, there are few international standards which regulate its use. The Convention on the Rights of the Child prohibits the application of life imprisonment without parole to juveniles below the age of 18, and under the Rome Statute, which provides for the gravest offences within the jurisdiction of the International Criminal Court, war crimes, crimes against humanity, and genocide, life sentences must be reviewed after 25 years.
So why do you think there isn't a international standard for life?
So I think it's firstly because crime across the world is so different.
Okay.
A murderer in Norway is not the same as a murderer in Mexico or a murderer in South Africa. And even the circumstances, the hope for rehabilitation, that country's ability to house offenders for a specific life period is not the same. So for any international body to say this has to be the minimum, it can't be any shorter than this, would be, I think, taking away from the fact that crime is so different in so many different countries. Okay. I can understand them having rulings around children who've committed crimes. That's important because that's a human right that should be protected.
I want to speak to you about that.
Okay.
The kid that I think he was 17 or 16.
Yeah.
He raped someone when he was 13. And then he murdered someone when he was 16.
Yeah, 17.
17.
Yeah.
Yes, he's an exception, I'm sure. Please God. But how can someone like that not be sentenced to life? Because let's face it, if you're raping at 13 or murdering at 17, something went wrong somewhere along the line. And you often hear of children being tried as adults. And I often go, but why? Did they really? This kid, there is no question in my mind.
Yeah, absolutely. So I guess what we know in America has been tried as an adult. In South Africa is essentially the age of when child offenders are assessed psychiatrically, it'll be determined whether they have criminal culpability. And for us, that would be still not necessarily tried as an adult because your sentencing will be different, but are you culpable? And in this specific offender's situation, the first time around, he was found not criminally culpable. However, the psychiatrist made very big notes on his, and prophetic, unfortunately, notes on his analysis saying that this child needs intense therapy and management sessions, which were supposed to be managed through the court. And because his words were, the next time he does this, the victim will not survive. And she didn't. So that is something that bothers me about the Child Justice Act. I understand why it's there and why it does what it does, and it protects children. If at any point in an offender's offending career they can be rehabilitated, surely it is when they are 13 years old.
Yeah.
So we're giving them the best chance possible, but it's also terrifying because we don't know that this is an aberration and not the norm.
Yeah. Okay. Let's take another quick break and stick around. We'll be right back. You mentioned that you are going to be making a submission to Parliament.
So my submission to Parliament will be around my experiences with victims of violent crime. And it will certainly include an element where we can have a very basic system that stops victims having to be responsible for their own ongoing justice, which is what we're making them responsible for now. And that will definitely be part of my submission, is just a really simple database where, victims can submit their details so they don't have to go through this palaver all the time of updating their details every time they move and all the rest of that, and get SMS updates or email updates when an offender is moved from facility to facility. Just small things like that, that'll definitely be part of my submission.
Can the accused please stand? The South African government has decided to act decisively to stem the growing tide of conscientious objectors. It is my duty as a magistrate to protect our beloved republic from young men such as yourself who hold the system in such contempt. I therefore find you guilty as charged. I sentence you to 90 days in military custody. You'll be escorted to the holding cells below.
In 1971, Thomas Budge, a young gay Jehovah's Witness, refused to serve in the apartheid military. He was sent to the military detention barracks in the then Voortrekker Hoogte.
Welcome to your new home for the next 3 months.
He was marked as a troublemaker, and they wanted to make an example out of him.
Private Budge. The sergeant accuses you of refusing to wear your uniform. And here you're standing kaal gat in front of me. What do you have to say for yourself?
Captain, I stand here stripped naked in front of you because I'm not an enlisted member of the South African Defence Force. Neither Sergeant Vermaak, the corporal, you, nor any other officer has jurisdiction over me.
Is that so? Very well then. I find you guilty of insubordination and willful disobedience.
How long will they keep him in detention? And how will his parents and church react when they find out that he is gay? Based on a true story, Stripped is South Africa's first feature-length audio drama podcast, releasing October 2024 on the website startlivingmy.life and wherever podcasts are available.
Keep right on to the end of the road. Keep right on to the end.
And we're back. So, Nicole, have you watched Storytime yet?
I have indeed.
For those who haven't seen it yet, here's a quick recap. In May last year, the partner of a friend of mine threw a kettle worth of boiling water at me. In the episode, I recount the story of me laying charges and then trying to navigate the criminal justice system. I also talk about getting trauma counseling and how it helped me face my attacker and ultimately forgive him. So, when I needed to speak to someone about the trauma of parole, I could not think of anyone better than Karin Pampel, the trauma counsellor who helped me.
My name is Karin Pampel. I'm a registered trauma counsellor, dealing with all kinds of traumas. A lot of things are actually classified as trauma. It could be anything from bereavement to family issues to the hijackings and crime experiences that people have.
I first asked her to walk me through how trauma affects people.
Yes, I think it's important to be cognizant of the fact that everybody's different in how they respond to trauma. I also believe it depends on what else you may have been through before when you actually experience current trauma, and that one has to be cognizant of. And that brings us to the point of how important it is to actually get some professional help after you have experienced trauma, in order to have that safe space to process it, to have a space where you can express your emotions and, just find the necessary help in order to walk yourself through that traumatic experience and get to the point of acceptance, which is quite a process. It's not always that easy to get to that point of acceptance.
Okay.
Like with bereavement, a lot of those stages, liberos stages, happens in a lot of other traumas as well, going from the shock and denial of it, the anger, the bargaining stage of what actually happened to me, the psychological effect of it, and then working towards acceptance and wanting to obviously function normally again.
So I may be showing my age here, but there used to be an ad played at the beginning of videos that you'd hire at video shops. I don't think I need to explain that to the younger viewers. But it was a kid watching a movie, and then the movie would end. You turn off the video, you go to bed, and you come into bed, and you'd see the movie flashing on his face. And the thing was, the effects remain long after the movie's ended. And as someone who experienced trauma pretty recently, I can fully vouch for that. There are some times where I am woken from my sleep because hot water flew at me. So do you find that when you're interviewing people for your books, for your podcasts, that you are almost a therapist to help as they work through that trauma?
Yeah, so I think something that I discovered relatively early on was the power of the story, the power for the storyteller as well as the listener. And what I started getting back from people who would share their traumatic events with me time and again was when they would listen back to it. I was essentially asking people to tell their story chronologically, or I was telling it chronologically and they were filling in the gaps. And once they'd heard that story chronologically, it took them out of that moment of trauma, which very often becomes the focus, that moment of, for instance, the hot water flying at you. The trauma sufferer, what I've learned, focuses so much on that part that you almost lose perspective over everything around it. And a lot of people have said to me, hearing their stories on the podcast told from start to finish has given them greater perspective over things that they'd forgotten, hadn't understood, and has been very healing for them. So, you know, that has been really incredible for me. And yeah.
I must say, Storytime has done a ton of healing for me. It went out, end of last month? And in that time, because I told the story, because I got everything out, and, you know, I'd never really told the story, as you say, from start to finish, where I had to really think about everything else that went on before he attacked me and after he attacked me. I hadn't had to think about the bullshit I had to deal with the cops, where I had to go and find my own attacker, and then let them know, okay, you can come, you can fetch him now. He's there.
Yeah, absolutely.
I got angry all over again, but I didn't get angry because it was me. I got angry because this poor guy he's traumatized, and you want him to do this. It took me completely out of my out of my own story.
Yeah,
and I could see it from a much look at the much larger picture. I've started throwing away getting rid of a lot of stuff of his that he just abandoned. So I've done a massive cleanup of my life, and I did find that has also helped me with the healing process. So I mentioned earlier how Karin gave me the tools to face my attacker, and how I found that experience quite liberating in hindsight. In the moment, I didn't feel very strong. I didn't even speak to him in the moment. He wanted to apologize, and I let him. That was it. But it was good for me in the long run. I asked Karin about the benefits of facing one's offender. So when it comes to violent crime, do you feel that facing the offender holds some benefit?
I believe it can hold some benefit, but it also depends on the psychological and emotional state of the victim, whether they are at a point where they are actually up to it to face the offender. But importantly, if they have already received a bit of counseling, they've processed what's happened to them, then it can really be beneficial in the sense of it can bring closure. It can actually provide them some mastery over the situation and give them an opportunity to become the victor instead of the victim. And yes, it can really be empowering for them to actually, go through that challenge of saying, I will actually face my offender, and it can really help them to get that closure and mastery.
So in your book on Sizzlers, you speak about how during the victim-offender dialogue, Lee Visser found facing Adam Wust empowering because she saw that he wasn't the boogeyman that had been in her childhood nightmares.
Yeah.
Is this common among victims?
It's certainly, I think for anyone who's suffered a traumatic incident, if the person remains faceless, it can make things worse. And I've certainly seen it with quite a few different families where the VOD process does become that opportunity, so victim-offender dialogue does become the opportunity to face the person that did this either to them or their loved one. And that can be very empowering. As Karin says, it can also be traumatic if it's not the right time for the victim. But also, I'd like to point out if it's not the right time for the offender. Because not every offender doesn't want to tell the truth. Not all offenders are lying who just want to grab control. There are many like that, but they're not all like that. Some of them have gone through a process of healing, and they are ready for a victim-offender dialogue, and that's positive, and it's a great thing. Where, in Lee's circumstance, despite Adam Wust actually still continuing to lie and him not having been ready for a victim-offender dialogue, it still gave her some benefit, which was helpful, but that's not always going to be the case.
Yeah. So the victim-offender dialogue has the potential for re-victimization. And I discussed the impact that the parole process has on the victims with Tania.
Do you feel that there is a lot of re-victimization, especially with them not getting all the information as you just explained?
Absolutely. For a moment, just put the idea of the information that they don't get, put that aside. Just visualize or understand that victim, which now, as you said, includes those who's had a family member that died, that victim must go and sit in a small confined space in a room, literally a room, where they must face the offender or the murderer of their child or their loved one. So it's an enclosed, confined space where they must face the offender, and it's definitely very traumatic, and it's often secondary victimization.
What could be done to actually to minimize that re-victimization? How could it be improved?
The only thing I'm an attorney, I'm not a psychologist, so I think this question would be better put to a psychologist, but logic suggests proper preparation of the victims for what is going to take place. That's what I find with my clients. It's just having me there as a support and having me there, and I'm not allowed to speak, just knowing that they've got that person that's there with them, that already helps. Understanding the process helps. But the victimization also comes in where victims have not been informed that a hearing is going to take place. Or if they have been informed, haven't been properly educated as to what they're allowed to do on the day. So being in the confined space, facing the person, it's unfortunately unavoidable.
Okay.
Because for them to be part of the process, they must either be there in person, or of course they can make written or video recommendations.
Now, this is the other reason I wanted to speak to Karin, because she is the kind of professional that Tania suggested I consult. And Karin agreed that there must be more focus on preparing victims before they're brought into the parole process.
I think, one has to be aware that when people go through this process of being aware that this person may be going on parole and the process is on the go, I think when an offender is granted parole, it can have significant psychological effects on the victims, their families, and the general public, depending on who the offender is. And the extent and the nature of these effects can vary depending on the circumstances of the crime and the victim's coping mechanisms as well. So common psychological impacts are re-traumatization. It can actually, have the effect that the victims relive the trauma of that crime. And this can sometimes be as intense as when the crime occurred. It can lead to reliving that immense fear and really feeling like it is happening to them all over again.
Okay.
It can also lead to extended physical effects of the trauma, feeling shaky, all those symptoms that one can experience. I really think it's most important that those authorities in control of the parole procedure, they need to be aware of the psychological, emotional, and physical effect on the victims. And these authorities need to educate themselves about this effect on victims and be truly cognizant of this during the parole procedure. But following on from that, importantly, I believe people should be it should be ensured that they have some counseling in order to assess if they are strong enough to actually meet the offender, and to actually just assist them in being in a space where they can actually feel up to it to meet the offender.
So I haven't been through the parole process because, as I explained in story time, it never got that far. But I do have experience in the lack of compassion for victims in the criminal justice system. And I know some police stations have trauma counsellors who help victims of violent crime, but should this not be standard across all police stations?
It absolutely should. So the victim counsellors that I'm aware of that currently exist at certain SAPS offices are volunteers. So they are there, their time is not paid for. They're there because they want to offer a service to their community. And it should absolutely be something that is available, so I don't often use America as an example, but in this case I will. They actually have quite an interesting system where once you have become a legal victim of a crime and there's charges laid against someone in which you're a victim, you get allocated a victim advocate who then links you up to their system, which gives you free counselling sessions to a certain extent. I don't think it's a huge number, but it's certainly far more than what we're offering South African victims of violent crime. And that's something I'd love us to work toward having.
Funny enough, that was actually going to be my next question, is with me, I had to go to Karin myself. I had to pay for my own session with Karin, and I didn't have the money. I didn't have the money. I'm sitting in, going through that totally broke me. And so making money was just not something that I was even capable of doing. But surely there should be some sort of way that that professionals can be paid by can bill the state, so that at least there is that kind of support.
Yeah.
I just don't understand why, if they can't hire people to do it, at least contract out.
Yeah.
Do you think that would ever be something that could be done?
I'd love to see. I mean, it certainly could be done. Whether it will be done, and and it certainly should be done. It's a matter of many similar issues throughout our system as resources. We're under-resourced in most departments, in various government institutions, but I think that the South African justice system is currently laying far too much responsibility on the victim for them to get through this process on their own. And there are very simple changes that could be made, such as 1 or 2 counselling sessions that would make all the difference in really the general mental health of our society as a whole in South Africa, because many victims, or many South Africans, have been victims of some type of crime. So yeah, absolutely, it's something we should look at.
You mentioned that you are going to be making a submission to Parliament. Talk us through that, and also with this what we've just been discussing now, could something like this not be a part of the criminal justice reform, not just parole reform.
Yeah, so through Sizzlers, very glad to say that I networked with a couple of other people. And when the new, with our last Minister of Correctional Services, he had also promised us a parole review, and that didn't happen at that time. The new minister that has just come in has promised us the same thing. And in addition, he has invited myself and a few other affected individuals to submit make submissions to the parliamentary committee that will essentially set out how this review happens in the parole system. So my submission to Parliament will be around my experiences with victims of violent crime. And it will certainly include an element where we can have a very basic system that stops victims having to be responsible for their own ongoing justice, which is what we're making them responsible for now. And that will definitely be part of my submission, is just a really simple database where, victims can submit their details so they don't have to go through this palaver all the time of updating their details every time they move and all the rest of that, and get SMS updates or email updates when an offender is moved from facility to facility. Just small things like that, that'll definitely be part of my submission.
Let's talk on that briefly. When it comes to the victim-offender dialogue, the department is supposed to get hold of the victims and go, okay, this is now happening. How do victims get their name, get their details there? Is there a central database that they can go online and just update it?
Sadly, no. So we don't have a central database.
How the not?
Yeah, well, there we go. So at the moment, victims have to either maintain contact with the SAPS office that handled their case, and we know how overburdened SAPS detectives are. That's probably never going to go anywhere. Or they have to stay in touch with the correctional facility that is housing the offender. And I have probably 10 cases I can cite you of personal experience where our correctional facilities don't even know where the offenders are. We've had victims go to the correctional facility where the offender is housed and they're told he's not here. And then they find him half an hour later. There's one victim I've dealt with who her dad was murdered by, there was 6 individuals involved in the case. And they can only tell her where 2 of them are. They've lost the other 4. So
how do you lose a prisoner?
Well, they lost 4 of them. And this is what victims are dealing with at the moment. And it's that simple database, which we could really link to Home Affairs. Victims could give permission to have it linked to Home Affairs, to have it linked to credit profile updates, so that they don't even have to do it themselves. Anytime they, on this big system we've got, updates SARS, whatever it may be, updates their address and telephone number, updates it on the victim, the system to assist victims.
Yeah. If they can do it with RICA and FICA, I'm sure they can do it with the criminal justice system.
Indeed.
One thing that I tend to forget, and you actually mentioned it earlier, is offenders are people too. I lost that realization going through my ordeal, where this guy was a friend. And I'd known him for almost a decade. After he did what he did, he ceased being human. And it was only through Karin that I was able to go, actually, maybe I shouldn't, go after him.
Yeah.
to the full extent that I can. And Julian and I actually spoke about this as well.
There is a very fine line, from what I'm gathering, between not being unfair to the perpetrator, but also not allowing the system to re-victimize the victims and the victims' families.
And or re-victimize the perpetrator in the sense that the perpetrator is then punished excessively. So at the end of the day, what the system demands is that a rational decision has to be made on the basis of reaching an equilibrium of interests. So you have to take into all factors, but no factor must outweigh the other unless there's a very good reason for it.
Okay.
But one has to then reach a balanced decision. And my feeling is irrespective of the views of the families, if you have a situation where an offender has been a model prisoner, represents no danger to society, if released, has served the minimum period that the legislature has set for a person to be placed, then there should not be any reason why the person should actually do more, because then it becomes arbitrary. And that is the converse of the rule of law. And we're a country that has a constitutional democracy where we believe in justice and the rule of law, supposedly.
So one of the many similarities between our podcasts, and this is all your fault, because I learned from you, I learned from the best, and I'm one of the people, one of the fortunate few who can say I have Nicole Englebrecht, pod goddess, as my mentor. But one of the many similarities is that our podcasts are victim focused. Do you find it difficult to not dehumanize the offenders?
This has been a journey for me. In the beginning, I was very gung-ho on I don't think that focusing on the offender takes away from the victims, but I was very slanted more towards the victims, yay, and perpetrators, nay. And over the years, as I've been exposed more to the perpetrator side of things, I've come to, I think, have a more holistic view. I am still victim focused, always will be. And at the same time, I can see how the perpetrator's families certainly are victimized terribly. And I can also start to see certain perpetrators as human beings. So it has been quite a journey for me. It's no longer black and white. There's lots of shades of grey in between.
Okay, so I want to move on to something that's quite fresh. Nkosinathi Pakati, the Ecuadorian was recently convicted of 90 counts of 4 counts of compelling rape, 3 counts of causing a child to witness a sexual act, 43 counts of kidnapping, 2 counts of assault, and 4 counts of theft. He was given 42 life sentences and a further 791 years and 6 months in prison. I've heard conflicting reports that he was declared a dangerous offender. Is this true?
As far as I understand, yes, it is.
Okay. Now, I want to discuss this dangerous offender determination. The first time I came across it was in your book on Sizzlers. Could you walk me through what this is?
So the dangerous offender determination in South Africa is essentially the closest we have at the moment to a whole life tariff. What it does is it takes the power away from the parole system in the process, in the offender's process, and it hands it back to the judiciary. So an offender who is determined to be, through a process of psychiatric assessments and other criteria they have to meet, determined to be a dangerous offender, will not become eligible. He will very likely be given life sentences if they are, and I say he, but there is a female dangerous offender in South Africa. And what happens is when they reach 25 years, they do not automatically become eligible for parole. And their eligibility is not judged by the parole system through the Department of Correctional Services. Instead, they have to return to the judicial system and appear before a judge, who will then weigh up the legal side of their crime and how far rehabilitated they may or may not be, and make a determination whether at this point or in 10 years' time, not 2 years like it usually is with the parole board, they may be judged for eligibility again.
Okay. How frequently is this determination made in relation to violent crime?
Nowhere near enough. This is the first, with Pakati, it's the first I've heard of it. I mean, there may be the ones that I haven't heard of, but there have been many, many offenders who have gone through the system in the last 2-3 years that I have thought absolutely should have received a dangerous offender determination, and they have not.
I actually spoke to Tania, as a lawyer who deals with the victims, and whether she feels that utilizing the dangerous offender determination more frequently would improve the criminal justice system.
All right, so I'm not a criminal law lawyer at all.
Okay.
So that's a totally different field of law. But some time ago, I did actually phone Julian Knight and I asked him whether it's used often enough. Because I think yes, it's there, it's part of our law. I do think that judges should use it more often, because what would that mean? And I'm speaking from a victim's perspective. From a victim's perspective, it would mean that the judge makes the decision whether this person should be considered. That means that the victim doesn't have to either go and attend a victim-offender dialogue session and after that appear before parole board to oppose this person being granted parole. So I think from a victim's perspective, most certainly, I think it's a brilliant suggestion, and I do think it's something that should be used more often.
Why do you think it's so underutilized?
So judges in South Africa are not compelled to consider the dangerous offender determination when they have an offender sitting in front of them that they've just handed down a life sentence to. They're not compelled to consider that. And as a result of that sort of loophole, if you want to call it that, in the legislation, the responsibility has been passed on to the prosecutor to ask for it.
Okay.
And there's quite a few added steps in having someone determined to be a dangerous offender. That includes additional psychiatric reports. There's quite a bit more little, paperwork that goes into it, because it's an important thing. And I think what we're seeing is, with prosecutors, like so many other systems in our country, being under-resourced and overworked, prosecutors are not necessarily having, motivated, if you will, to push to spend that extra time to get that determination through. And I think that's where we're falling down. Another side of it, unfortunately, is our mental health facilities that do court psychiatric assessments are horrendously behind. There's one case I'm aware of where an offender, or an accused rather, has been waiting for 1.5 years for a bed at a psychiatric hospital so that his trial can begin.
Oh, wow.
And that's not just damaging to the victims, that's damaging to the accused. That's taking away his or her right to a speedy trial.
Yes.
So I think those are the real reasons that it's not being used nearly enough, and we need to fix those reasons because we've got a powerful tool in our hands here, and if it's used correctly, it can really benefit the Department of Correctional Services, the SAPS, almost every single element of the system can be benefited by using this piece of legislation that exists and is so underutilized.
Funny enough, Tania actually agrees with you.
Oh, good.
Because I asked her what options that we had to, instead of let's listen. Penal Reform International is staunchly against life without parole. And in a way, I do see their point. But what alternatives to an open-ended non-parole period could be introduced to protect victims and their loved ones from potential re-victimization during the parole process?
So I think that's where we will go back to what Nicole has suggested. And that would be for a judge at the time when he sentences the offender to have that person declared as a dangerous criminal. So I think that would be my answer to that, because there is a school of thought that says, they want to give that offender the benefit of the doubt. They are hoping that when they are incarcerated, that they are able to rehabilitate that offender. And there are legitimately offenders that have rehabilitated, and that's playing a tremendous role in society. So yes, I do understand that school of thought.
So how would we, the public, because not all of us are going to are fortunate enough to be able to make submissions to Parliament, to parliamentary committees, but how would we, the public, go about saying, we have this tool, let's use it?
So I think in this case, and again, I don't usually advocate using social media too much as a tool because it can be very damaging, but I think that's a great place for the public to exert their power, is in, following organizations or people in the public domain who are pushing for parole reform, following them on social media platforms and taking their lead from these organizations and individuals in what do we need? Do we need people to sign petitions? And even just, the power of sharing and educating others about what is happening. That's one of the main reasons that I wrote Sizzlers, was really to educate the public about what is really happening in our parole system and how it affects them as South Africans.
Yes, I agree. As someone who's covered Sizzlers, the information you gave on what actually happened was pretty much just to set the scene. And your book focuses very much on the parole process, which I think it's an essential part of the story that a lot of podcasters tend to not cover in a case. They don't. They. Let's be honest. We're all a little twisted for our interest in true crime.
Yeah.
And our audience is also a little twisted because they go there. And I've often had people say, "Why so many trigger warnings?" Yeah, because that's what they're there for. They want the blood and the gore and the guts and the horror, and it's. I'd say 75-80% of the audience goes there for that.
Yeah.
And it's why I think your book is so vital, and why I was so proud to have been a part of it, was because it goes where most podcasters either fear or couldn't be bothered to tread.
Thank you.
Okay, so I think we've pretty much covered this topic from start to finish. There's just one thing I want to do. I want us to go through the 4 questions that I I posed at the beginning.
Sure.
So, is the South African parole system failing victims of and their family of violent crime?
Simple answer is yes. In its current iteration, how it's currently operating, I'm seeing desperate and terrible failures every single day.
I agree with you. I think it is failing, but I don't think it's beyond repair.
No.
The second one was, would implementing a whole life enhancement for those sentenced to life imprisonment for especially heinous crimes improve the South African parole system?
I would not oppose it. I'm someone who likes to put my energy where it can actually make a difference. And I think if we have to pick one, no one's telling us to pick one, but if we have to pick one, let's put energy behind ensuring that the dangerous offender determination is used more often, and there's legislation to compel judges to do so. But I wouldn't say no to a whole life tariff if it was offered.
For me, I was all in on this. Absolutely, 100%. I'm there.
Yeah.
Working on this episode, not so sure anymore.
It's complex.
For certain crimes, I definitely think that, throw them away, put them away and throw away the key. I could get behind that. But especially speaking to Julian, I realized that taking away that glimmer of hope of rehabilitation is cruel and inhumane. I'm a changed man. So the third one was, would a sentence of life without the possibility of parole run afoul of the South African Constitution? I think very much yes.
Yeah.
I did try and get a Constitutional Court judge to speak to me, and I was told I'm afraid I can't. Sorry. So, but again, my conversation with Julian did change my view on that. We removed the death penalty because it was cruel and inhumane. I don't see the Constitutional Court going, okay, well, we'll just replace it with something else cruel and inhumane. The last one was, is there a way to ensure unrehabilitatable offenders are kept off the streets without changing the laws to accommodate a life without parole sentence?
Yes, so certainly for me that happens at parole review level. That happens when we ensure that we have the right bums in the right seats, as they say, and having people who understand recidivism and criminology making decisions and holding them accountable when they make the wrong decisions. They're not going to get it right all the time. And, sometimes there are going to be offenders that look rehabilitated to everyone and they go and do it again. But when there's glaring decisions that this guy should not have been out in the street, and even DCS psychologists are telling you not to let him out, which has happened in many cases, and they've gone against their own psychologists. In those cases, they need to be held accountable. So for me, that's where it starts, is using the systems we already have properly and using the legislation we have, like the dangerous offender determination, more often and properly.
I think the dangerous offender determination it's a win-win for the system. Yes, the offender gets put away for a long, long time. And yes, the victims are spared going through the parole system, but there is the option for an offender to say, well, actually, yes, I have been rehabilitated. And I have proven that I am a changed man. So, like I said, I just see it as a win-win. But we just need to remove some of the red tape, some of the the issues that are making it more complex than it needs to be.
Absolutely.
And we need to get more people on staff.
Agreed.
I think that is the thing.
Yeah.
So, yeah. Do you have any final thoughts that you'd like to share?
I think we've covered quite a lot. It's in this journey. I've had the privilege of getting to know a lot of different people. One is a gentleman called Stefan Skutsia, he's quite open about his past. When he was 17 years old, he was essentially an orphan. He was living in an orphanage. And he was inducted into this, I guess it's almost a far-right white supremacist group. And he ended up in 1996 planting a bomb when he was 17 that killed 4 children in Worcester in the Western Cape.
Oh, yes. Okay.
Yeah.
I remember that.
And I can very proudly sit here today and say that Stefan Skutsia is a very good friend of mine. I met him through the Samurai Sword book.
Okay.
He read it. He interviewed me about it. He's been on parole for the last 12 years. He is now a writer. He's just published his own his third book. He's a journalist. He works for a radio station. He promotes authors in South Africa. He's a dad. He's probably one of the best dads I've ever seen. He's really amazing. He's a husband who carries his wife around on his hands. And Stefan Skutsia has been the balancing point for me, where I've had to say, parole is not a bad thing, because look what can be achieved. However, we've also seen many situations where the opposite of Stefan's has happened. And even Stefan acknowledges that there are offenders he's been in a maximum, correctional facility and lived with lifers. And he said that there are many of those guys that he would not let out. And, I think there is hope in our rehabilitative parole system. It needs to be implemented in a way that's going to be beneficial, that's going to lead to more Stefan Skutsias and fewer of the many, many other examples we have.
Yeah. And that's our show. But before I get to the housekeeping for the 7 people who tuned in who aren't already diehard Nicole groupies, tell us where people can find you.
Thank you. So www.truecrimesouthafrica.com. That's the website, and that will lead you to, if you want to listen on Spotify or Apple, you can. And the books are available at all good bookstores. Also on Audible in the ebook form, and audiobook for Samurai Sword, Sizzlers coming soon, and Killer Stories is out as well.
Oh, excellent. So thank you so much for sitting down with me, Nicole. This has been a long time coming, and I'm thrilled that we finally got the logistics sorted out. I also want to give a massive shout out to Tania Koen, Julian Knight, and Karin Pampel for sharing their expertise with me. But now it's your turn. What are your thoughts on the South African parole system? Do you agree? Do you disagree? Have your say in the comments, but please, let's keep it civil. And remember that it is okay to ask for help if you have experienced trauma. To get hold of Karin, you can go to her website, josiecounselling.co.za. This is not a paid sponsorship. I am immensely grateful to her for guiding me out of the darkness, and I'm sure she can help you, or at least assist in finding you the right person to speak to. At Crime Most Queer, we'll be back next month, and I'm working on cleaning up our audio-only back catalogue, which I will also be adding to YouTube. So, if you want to come along with me on my adventures in YouTube land, smash that subscribe button and ring the bell to be notified when we drop new videos. If you're listening to the audio-only version on Apple Podcasts, Spotify, or wherever you get your podcasts, why not leave a review? I genuinely appreciate the feedback. Also, ACMQ is on Facebook, Instagram, YouTube, Patreon, and Buy Me a Coffee at the username @ACMQpod. And you can find our discussion group at facebook.com/groups/ACMQpod. Please note that I deactivated the ACMQ podcast Twitter handle, so anything coming from that username is not from me. But until next time, I'm NJ Hawkerby, and thanks for watching, or listening, whichever the case may be. Cheers.